Well, Justice Breyer, greetings from Malta. And on behalf of the International Institute for Justice and the Rule of Law, let me thank you for being part of the commemoration of our 10th year anniversary. It's really an honor to have you here with us. As part of the 10th year anniversary commemoration, we're organizing a series of conversations about our work. The purpose of the conversations is really to take stock of the work that we have been doing in supporting criminal justice practitioners, and that includes judges, prosecutors, investigators, penitentiary officials, and other kinds of officials from both common law systems and civil law systems. We work with them really to help support them in their efforts to handle serious national security cases in line with human rights and the rule of law. I have really personally been very inspired by your own writings that deal with the tensions that are inherent in the handling of national security cases. And so those are the kind of tensions that I thought I might ask you about today. And hopefully your insights, your experience can help us reinvigorate our commitment for the next 10 years of our institution.
Well, thank you for inviting me. I'm very glad to be here via Zoom. It works, apparently, and I think what you're doing is important. It's important. It's very hard to do. It's a long-run payoff, and the more you keep doing it and the more you think about it, I think the better off every one of the countries that's involved and many others too are better off. But we can go into that in our conversation. Right now, I just want to say thank you for inviting me, and I'm very glad you're having this meeting, and I'm glad you do what you do.
Thank you very much, Justice. My first set of questions for you has to do with the tensions that are inherent to national security cases, such as terrorism cases, which are our focus here at the INJ, but you've written about these tensions in a very compelling way. First of all, how you see the role of courts, and if you like, other judicial institutions in helping strike the balance that helps mediate this tension between, for example, national security and individual liberties. What is the role of courts ultimately in striking that balance?
It's taken a long time. What? To what? I mean, think of a terrorist group. The terrorist group causes a great deal of hardship, trouble, etc., which you know better than I, but they think they're right. Okay? They think they're right. Otherwise, they wouldn't do it. So, it's very tempting when, say, the government catches them to say, maybe you think you're right, but you're wrong and you've killed a lot of people. We're going to kill you, period. Now, Cicero said that. How long ago? I mean, 2,000 years ago. He said, now I've quoted it a lot because it's a very descriptive statement of the role of courts as it was for many, many years. He said, arma dicent, legis silent. Now, I translated that with my Latin teacher in high school, shuddering probably. I translated that as, when the cannons roar, the laws fall silent. No, I thought that was pretty good. But someone at one of the meetings I went to said, don't you know the Romans didn't have cannons? I said, no. But that's the point. You see the point? And Cicero was followed for years, for decades, for centuries. You're in the middle of a war? It's terrorism. Forget it. Kill them. That's it. No trial. No need for anything else. And you see from time to time somebody putting up a little protest. Justice Jackson at Nuremberg. A great speech if you've never read it. And he said these Nuremberg trials are the greatest tribute that power has ever paid to a rule of law. Go look at the history of the United States. And that described very much what happened in the Civil War, in the First World War. And the Second World War, there is probably almost no one at your meeting who doesn't know this, that we took Japanese Americans, 70,000 Japanese Americans, that the Second World War, Japan had bombed Pearl Harbor, and Earl Warren, who said it was the worst thing he ever did, and many others got the government of the United States to take 70,000, more than that, but 70,000 were American citizens, and move them to camps. camps from their farms where they'd worked. And case was brought in the Supreme Court. And Korematsu, who he brought it, he was certain he'd win. So was the ACLU. So were a lot of groups. But they didn't win. They lost. And in Korematsu, the Supreme Court said, no, keep them in the camps. Maybe there'll be a bombing or they'll give information to the... Well, they had no evidence of that. And later, the evidence was to the contrary. You see? But Black, who was a great justice, said to the Supreme Court when these cases came up, look, somebody has to run this war, Roosevelt or us, and we, the courts, can't. And so Korematsu was upheld, and they were in camps during the war. Amazing, amazing. So when did things begin to change? I think after World War II. They began to change with Nuremberg internationally. And in the United States, they began to change with the steel seizure case, where during the Korean War, President Truman had seized the steel mills, and the Supreme Court said that was illegal. They said the president couldn't do it, even though there was a war going on and they needed steel. Why? Well, I think, my own view, the Supreme Court thought that Roosevelt and Truman had gone too far. They'd gone too far outside the Constitution. And maybe they were annoyed at Roosevelt, but Roosevelt was a very popular president and Truman was not. So it's easier to get criticism of the popular president when you criticize a different president who isn't. But that's politics, that's not law. And what they did was they said Truman was wrong, and they held it. And then look at your Guantanamo cases where you got that quotation from, no blank check. Well, that was a radical change from what had been mostly the history of this country. And 4 cases, and they said that in Guantanamo, the court said, no, you cannot keep those people in Guantanamo without giving them a hearing, without letting them go to the courts if they want to. The rule of law, courts coming in, like us, lawyers, judges. That's what our court held. And George Bush, who was president of the United States, said, and this is a new attitude, he said, I don't agree with the Supreme Court, but I'll follow it. The same as Al Gore said after Bush v. Gore, a very important case for him, is about a different subject, but he said, don't trash the court. You see? That's quite different from Andrew Jackson in the Indian Wars in the 1830s, where Jackson said about Chief Justice John Marshall, he made his decision. The decision was that northern Georgia belongs to the Cherokee Indians, not to the Georgians. He made his decision, said Marshall, supposedly. Said Jackson, supposedly. Now let them enforce it. See, you can't. Judges? How are they going to enforce anything? I mean, there may be 900 judges, 9,000 judges, 90,000 judges. There are 320 million people in the United States. Those judges can't. They need the cooperation of those people. And that's called the rule of law. When those people in the country who aren't lawyers, who aren't judges, that they will understand the importance for their lives of following a rule of law, even when they disagree with that law. Well, suddenly it's that attitude. It's that attitude that has become popular after World War II. And by popular, I mean when the Marshall Plan, when Dean Acheson, when Harry Truman, and the others began with Britain, with Italy, with France, with Germany too, to develop a set of principles. Those principles included democratic forms of government. They included protection of basic human rights, a degree of equality, and above all, a rule of law, as well as some free trade, and as well as acting together in NATO, in other groups. In acting together, we will make certain that these principles, or will try, are actually followed. Radical step. And for 30, 40, 50, 60, 70, maybe 80 years, it worked pretty well as a set of ideals, and now we're questioning it again. You see why I think you're so important to this? Because it's a development, and it's a development in the direction of the rule of law. And we never can be certain that people in any country will in fact follow it when they don't like the result. But if they don't, I said this to the Chief Justice of Ghana, a woman in Ghana who is trying to have more civil rights, who is trying to have greater legal protections for democracy. Why do people do what you say in the United States, she said. And I said, it takes a long time, a long history, a long history. And what you must do, in my opinion, is you must get those lawyers or the judges, but you must get them, and not one person who isn't a lawyer or a judge will believe them, but keep going. And they have to explain to the 90% or 99% of the people in the villages, in the towns, on the farms, why it's in their interest to have a country that follows a rule of law, meaning they will follow a decision, even when they don't like it, even when they disagree, even when they think it's wrong, and many times it is wrong. All right. Why? In a word, turn on your television set, as we have, and see what happens in countries that don't follow rule of laws. Is that what you want? No. But you see what you're working on, in my mind, has been generally helpful to people. A rule of law that has meant greater human rights, greater freedom, greater liberty, greater equality, and fairness. And that's putting it pretty generally, but my goodness, that's what our history shows, in my opinion.
International dialogue is important in the development of the rule of law. Even if the rule of law really does develop also at the national level, but there's something about judicial dialogue, dialogue amongst practitioners. This is, of course, what we try to promote at the IIJ. But more broadly, I mean, I know you've written about the value of judicial exchanges in your own experience. I wondered if I might ask you kind of what you think what makes for a good judicial dialogue, a fruitful dialogue.
Well, it's not totally just going and meeting with some people. The judges are busy, so are lawyers. And you can go and meet with them and have a meeting, and sometimes that's helpful. When we've gone up and met with the Canadian judges, for example, we had a long discussion about how the Supreme Court of Canada, the individual judges, talk from time to time on television, even about what the work of that court consists of, how the court functions. Or the German court. The German Constitutional Court has greater acceptance in Germany than the United States has, than the Supreme Court of the United States in the United States. And they have some very interesting opinions, particularly recently, one about the use of economics and where the EU's use of economics fits within German law. Very interesting and helpful. The British court, the Supreme Court of Britain, fairly recently wrote an opinion about the constitutionality. And remember, Britain has no written constitution, unless you want to count the European Convention on Human Rights. But they wrote a very interesting opinion about the constitutionality under an unwritten constitution of the prime minister dismissing parliament in a procedure called proroguing. I recommend that to judges. They'll learn something from the way they've written that, and different things all over the world. But you'll learn something, and it's worthwhile having the meeting just so you know the people, and just so that you see that you have common grounds. But the main thing is this, in my opinion. The main thing is that more and more, after the end of World War II, again, a development up through the beginning of the 21st century and somewhat longer, but a development along the following lines. The more and more countries, I don't know if that's true right this minute, but more and more countries have constitutions, written or unwritten, something like our own in the United States, protecting the basic democracy and human liberties, basic liberties, human rights, and so forth. More and more have constitutions like that, written documents even like that. More and more judges do things like the Supreme Court of the United States. They try to make laws? No, they interpret the Constitution, but it isn't computer science. I mean, computer science is not judging. There's much more human interaction, and there is much more concern about how people are going to live under the rule of law that comes out of an interpretation. All right? They have problems like ours. Do you think immigration, to reach a touchy subject, do you think immigration is just an American problem? Ha, ha, ha. Go read a few French newspapers, or Britain's, or it's all over the place. It's a problem A lot of places. And was COVID just United States? Not at all. Environment, tenure, and they're lawyers and judges, people with jobs like mine, documents like mine, problems like mine. And they come up and they just make decisions. So my view has always been, hey, read them. Don't read every one, you can't, but you'll know. Get some law clerks or get some professors or get some people to tell you which are the important ones that affect you, judge, and then read it. You may learn something. You don't have to follow it. It's not your country, not your courts. You don't have to follow it, but you may learn something and you may decide, no, I'm going to go this way, not that way because of what you learned. And that's become more and more true. And I think as a tendency, it's a very, very good thing because the world does have similar problems. And it's your job and my job to try to deal in a tiny way with one part of one of those problems.
So did you ever have an aha moment when you read, for example, a foreign judgment, or when you spoke with an overseas counterpart that really gave you an insight that you could import into your own work? Or is it more of a spirit of consultation? I'm trying to
Well,
understand.
no, it's both. It's both, actually. But just if I go, well, I'll say recently what I've been thinking of, but for example, Switzerland has a federalist system, and so does Germany to a degree. And sometimes when you read some of their cases, you say, we have a federalist case, a federalism case, a case about power of states and power of the. Well, I've learned something there, and I did, and I put it in an opinion. I can't say it's the most interesting thing ever, but and recently we had a pretty good discussion with the French judges. So the French judges were not having dissents; they leaned against having dissents, and I thought they were wrong on that for a set of reasons. Well, in this book that's coming out in March, actually, I just wrote it in a review of a book that Robert Post at Yale has written about the Taft Court. Very interesting book. And they didn't like dissents. Why? Because they thought there was more acceptance of the court's decisions if they didn't have open dissents, even if the judges, some of them disagreed. Well, there are good arguments on both sides. So I've suddenly gone back in working on this to my conversation with the French judges at the Conseil Constitutionnel when Badinter, I think, was president, and Guy Canivet in the Cour de Cassation. And they're pretty interesting. There are good arguments on both sides. So my mind is slightly different. Not that that matters tremendously, but I've learned things. No question.
I appreciate your sharing that example, because one of the things we deal with in the work of the IIJ is the difference in the different roles of judicial actors in systems that come from the civil law tradition versus those that come from the common law tradition. And we do our best to try to facilitate a dialogue across that. But
yes, you can. Yes. I mean, I sat for 14 years on the First Circuit, and I was eventually Chief Judge of the First Circuit. Well, the First Circuit includes, as we said earlier, Maine, Massachusetts, New Hampshire, Rhode Island, Puerto Rico. Puerto Rico has a civil code. Puerto Rico does not want to have a common law system. And the great judge there, Trias Monge, wrote an opinion where he said relevant precedent is civil law countries, Les Frères Martin, or various treatises, but not, he said this, but I don't know how well it actually happens. But nonetheless, he said not the common law countries. But then because the cases would come up often through the federal courts to the First Circuit Court of Appeals, I ended up with a conclusion that they're not so different. I mean, if you have a statute of limitations case, they may use different words, they may use different precedents, or they may use different theories of what they say, but it's not so different. And so I don't think the judges or the lawyers, maybe they have to learn the lingo, they may have to learn the language, but I found it isn't tremendously different in cases, at least, that came up to the First Circuit.
I think it's also extremely important to, you're right, speak across systems, but also for criminal justice practitioners to be be able to communicate across linguistic barriers as well. And so that's here, as I was saying, we work in French, English, and Arabic. I know that you are a French speaker, and we really appreciate that. I think that's something important for our practitioners to continue.
Well, the common law system I read once, I don't know if this is true, but I think it is. But Cook was a great English common law judge, Lord Cook, right? And we've got a lot of our commercial law from him. And in reading this book, it said that he got a lot of his commercial law from Colbert, who was Louis XIV's prime minister and was interested in economics. And where did Colbert get it? He got quite a bit from the Arab countries. And nobody knows that. But there was a pretty good, originally before 1492, there was a pretty good system of Arabic law in Spain and in North Africa. And so Colbert learned some of that, and Cook via Colbert. There's more relationship between these countries than people often think. I mean, we know we got mathematics from the Arab countries, but people don't usually think of laws coming from there in the common law system, but some of it does. Don't ask me how much, I'm not an expert.
But I think many people in the audience will appreciate what you're saying. Justice, can I ask you about efforts to promote justice and the rule of law through capacity building assistance, the kind of things that the IIJ does, but of course that also the US government, foreign governments, US lawyers privately, universities, civil society. I mean, for decades there have been efforts to promote the rule of law in other countries. I think through the sharing of experience, through dialogues, through legislative drafting assistance, through all sorts of types of assistance. What role have rule of law assistance programs played in that, in your experience?
But overall, it's important to go back to Justice Jackson and say, what do you want? Do you want a form of political organization where when you catch a terrorist, you'll shoot him? And that will convince the other terrorists that they're even more right and you're even more wrong, in my mind. Or you say what you're accused of is killing another person or injuring another person. So we will treat you like we treat other people who go out and murder people, and we will have courts and laws, and you'll get a lawyer perhaps, and maybe it won't always work as well, but what we'll be doing is explaining to people why our system is a system where law is followed. It isn't the rights and wrongs of your particular grievances. And we treat people alike on that. We treat them alike. We give them fair procedures. And if they've committed a murder, they'll probably be convicted. And that's what we want to achieve. Why? Because we're fighting for a cause that is related to democracy, related to human rights, related to equality, related to rule of law. And that's what we're for. Not that we're against your particular grievance. We are, but maybe we are, maybe we're not. But that is what I think has to occur in the long run. Now, if we're near the end of this, I can tell you why I think so in words that are better than my own. Should I do that, or are there other things?
No, sir, please. I would really appreciate to hear that.
Well, it's because of my generation. I mean, I grew up, I was a young child in World War II, and I can remember the blackout curtains in San Francisco that we used to pull down. And I can remember the stories in the newspapers and Life magazine. It was a terrible war. And after, the writer, because you've mentioned French, the writer who appeals to me enormously is Albert Camus. That's my generation. And one of his great books that I like, and I quote it when I can, is La Peste. You know La Peste, the plague?
Yes, the plague.
It's a book about a plague that comes to Oran in Algeria. And it's really about the Nazis. It's symbolic. It's the Nazis that were in France. And how did we deal with them in France? And some people behaved well, and some people did not. And at the end of the book, he says, why did I tell you this story of Oran during this time, the plague? He says, I told you the story because I wanted you to know how some people behaved well and some behaved badly. I wanted you to hear their story. I wanted you to know what it was like. But he says there's a second reason, because the heroes of this book are doctors. There's a doctor, Dr. Rio, who's a hero. Okay, he says, because a doctor is in a profession where he does not explain why he does what he does, he just does it. He helps other people. He helps other people without necessarily a driving philosophy. He just helps. And I want you to see how that works. But there's a third reason. And the third reason, he says, parce que le bacillus de la peste ne meurt jamais. The plague germ never dies. It goes into remission. And it lurks. It lurks in the corridors, dans les greniers in the attics, dans the file cabinets, les dossiers. It lurks there for one day to emerge, and then for the for the benefit or the education or to the misfortune of a city, it once again sends its rats into a city that was once happy. That's what he says. That plague germ is there in every human being. It's there, and you can't get rid of it. The most you can do is send it into remission. And I like that paragraph that he has at the very end of the book, because that's what we're trying to do. We're trying to send it into remission. The rule of law is no guarantee we will, but it's one of the weapons that we use in order to fight that plague germ. And so I think he's writing a philosophy, but it's a pretty universal philosophy. And that's why it includes France, it includes the Arab countries, it includes Africa, it includes the United States. It's not simply one thing or one way. It's a way of all of us, whatever these countries are, trying to see that we have decent legal systems, that we treat people fairly, and we want that to spread. And not the only thing that will help, but it is one thing. And better one thing than none, and important. And that's why, as I've said for the 19th time, I'm glad you're having this meeting.
Thank you very much, Justice Breyer. I really appreciate the time that you spent with us, and I know that everyone here in the audience in Malta does as well.
Thank you.